Hi, Professor Fleming, how are you?
Very well, thank you. Very well.
Okay, let's start the questions. Vamos a iniciar con un poco del currículum del profesor Fleming. El profesor Fleming tiene un Bachelor of Arts, summa cum laude, en Political Science por la Universidad de Missouri. Tiene un Juris Doctor por la Universidad de Harvard en la Facultad de Derecho, es magna cum laude. Del mismo modo, el profesor Fleming tiene un doctorado en filosofía por la Universidad de Princeton. Del mismo modo, el profesor James Fleming ha escrito sobre el tema de derecho constitucional, teoría constitucional, y ha enseñado distintos cursos en derecho constitucional y ha escrito 5 libros de los que ha sido coautor. Entre ellos podemos encontrar Order, Liberty, Rights, Responsibilities and Virtues, escrito bajo la editorial de Harvard. Securing Constitutional Democracy, The Case of Autonomy, por la Universidad de Chicago. Y también tenemos Constitutional Interpretation, The Basic Questions, por la Universidad de Oxford. Del mismo modo también tenemos otros 2 textos, que es American Constitutional Interpretation, que fue escrito de forma coautoría con el Dr. Walter F. Murphy y Stephen Macedo por la Universidad de Princeton. Y encontramos por último el libro Fidelity to Our Imperfect Constitution con la Universidad de Oxford. Del mismo modo otros artículos académicos en que él ha participado como coautor y del mismo en que también ha podido dar una opinión en participación con la Universidad de Nueva York, entre otras instituciones. Professor Fleming, in your opinion, how important is the theory of Ronald Dworkin in the American philosophy of law?
In the American philosophy of law in particular, or in philosophy of law in the world?
In the world.
Okay. Well, but let me begin by saying that I really appreciate Imer Flores' gracious hospitality in inviting me to come to UNAM. We've had an excellent conference. There's been a very rich discussion of Professor Dworkin's ideas. I'm been very happy to meet many of the members of the intellectual community here, and I'm impressed with the knowledge and the vibrancy of the intellectual community at UNAM. It's been a wonderful conference and a terrific way to honor Professor Dworkin 1 year after he died. Now, I think that Ronald Dworkin is the most important legal philosopher and constitutional theorist of our time. And my whole professional life, I've been reflecting upon his ideas. I started graduate school at Princeton University in 1977. That was the year he published his first major book, Taking Rights Seriously. And so from the very beginning, I've been reading his work and building upon it in my own work. And I think that he is unmatched and unrivaled in legal philosophy and constitutional theory. And he was a very inspiring figure, a very compelling figure. He argued with great vigor, with incredible eloquence, and so we'll miss him. But he left an enormous contribution, and in the paper I wrote for this conference, I wrote it with my co-author and wife, Linda McLean. We thought the best way to honor Professor Dworkin would be to show how he had influenced our work, and also to show some of the projects that he left incomplete that we wanted to build on and carry forward. I could go on at great length about how important he is, but let me just leave it at that as an introduction. And we'll get into it more as we go through some of the other questions, I'm sure.
Okay, Professor Fleming. The other question is, what kind of reflection do you have about the work of Ronald Dworkin a year after his death?
Well, I guess I've already started to answer that question. I think that we miss him. Fortunately, he was an incredibly prolific author, so we have the corpus of his work to reflect upon. And also, he finished a book just before he died. And so there's new work still to reflect upon. His book, Religion Without God, and I have read it and I hope to come to terms with it, but it was inspiring and sad at the same time to read that book because his voice came through so clearly in it. It was, reading the book was like sitting in the seminar room hearing him talk again, because it was his voice so articulate, so powerful, so clear. But he was always extremely constructive in his work and always inspired others to build upon his work. And so it falls to us to carry on that work.
The next question is, in your work Securing Constitutional Democracy, the case of autonomy brought forward a constitution perfection theory. Do you consider this is the best way to interpret the American Constitution?
Well, that's why I wrote the book. Yes, I do. And that book does build upon Dworkin's work in many important ways. And one of the central ideas of the book is that we should interpret the Constitution. This was a book about the American Constitution. We should interpret the American Constitution so as to make it the best it can be. Now, that's a phrase Dworkin used, and I tried to carry it into effect in offering a general theory of the American Constitution. Now, it certainly had affinities to Dworkin's work, but Dworkin tended to write about particular issues, like the right to reproductive freedom, the right to die, freedom of speech, and all of his writing clearly grew out of a coherent vision of the Constitution as a whole. But he never sat down and wrote a book where he said, here is a theory that best fits and justifies the American Constitution. And I tried to undertake that task, building upon some of his ideas about constitutional interpretation, also building upon some of his ideas about the content of particular liberties protected by the American Constitution. There certainly are affinities between what I did and what he did, but I also built on the work of some other scholars like John Rawls, and so I wouldn't say it's simply or purely inspired by Dworkin, but Dworkin was certainly one of the important formative influences of it, in particular in the idea of that we should interpret the Constitution so as to make it the best it can be. And I also tried to articulate a framework of basic liberties that would show the system as a whole to be a coherent whole. In other words, not just to view the Constitution as discrete clauses. You know, you got the First Amendment protecting freedom of speech, you've got the 14th Amendment protecting due process. I tried to put it in a coherent whole and show how it could be justified on the basis of a particular substantive constitutional theory. And the idea of a constitution perfecting theory means not only that we should interpret the Constitution so as to make it the best it can be, which was the Dworkin idea, but also in American constitutional theory, many people emphasize rights to participate in the political process. And they write as if substantive liberties like reproductive freedom or the right to die are not part of our constitutional order. They say, well, those are just liberties that some liberal judges made up, but they have no roots in the American Constitution. I challenged that view, and I tried to argue that our Constitution protects substantive liberties like right of privacy, right of autonomy, right to die, right to reproductive freedom, right to same-sex marriage. It protects substantive liberties as well as what the American constitutional theorists call procedural liberties. And some American constitutional theorists who say the Constitution should be interpreted purely procedurally, they call their theories process-perfecting theories. The idea is that aggressive judicial review protecting constitutional liberties is justified only if courts are protecting rights to participate in the political process. So I tried to argue that that leaves out substantive liberties, and I argue that a full constitution perfecting theory would protect not only the procedural liberties but also substantive liberties related to personal autonomy. And so constitution perfecting theory means perfect the whole Constitution, not just the process rights. And in that formulation, I think there are affinities between my approach and Professor Dworkin's approach. I didn't put the ideas exactly the way he would have put them, but I think that I was very influenced by him in thinking about the Constitution in the way I did.
Well, next question is, according with the interpretation of Dworkin constitutional theory about the other elements that contribute of the constitutional perfectionism, are you agree or not with those elements?
Let me hear that again.
Yes. According with the interpretation of Dworkin constitutional theory about the other elements that contribute to of the constitutional perfectionism, are you agree or not with those elements?
Okay. Now, in our paper for the conference, I say we because it's a paper that my wife, Professor McLean, and I co-authored. We called the paper Dworkin's Perfectionism, and we distinguished three different understandings of perfectionism in constitutional theory, and we showed the sense in which Dworkin was a perfectionist, and then we tried to identify gaps, work that was left undone by Professor Dworkin, and we tried to carry forward that work in a spirit consistent with his work. So I think that the elements of perfectionism in constitutional interpretation that we said characterize his work, we do agree with. But we develop some of those forms of perfectionism in slightly different ways than he does. But and we offered these developments in the spirit of honoring him. So to give an example, one variety of perfectionism is that government should promote good lives, or that government should inculcate civic virtue, or that government should encourage people to exercise their rights responsibly. Now, there's certain strains of liberalism that reject all of that. They want government to leave them alone. They want to have their personal freedom, and they resent it if government tries to encourage them to exercise their rights responsibly. They resent it if government is trying to inculcate civic virtues, even though in elementary and high school education, government plainly does try to inculcate civic virtues through civic education and teaching the history of the country and the basic values of the Constitution. So we identified a sense in which Dworkin was a perfectionist. He rejected John Rawls's distinction between political liberalism and perfectionist liberalism. Dworkin said he was what Rawls would call a comprehensive liberal. And so, unlike Rawls, he didn't say that government should bracket, as they say, conceptions of the good life. Now, we showed the sense in which Dworkin was perfectionist in that he contemplated greater latitude for government, encouraging people to deliberate conscientiously before exercising their rights. For example, right to reproductive freedom. We showed that more than many liberals, his theory permitted that. So, for example, with reproductive freedom, some liberals would say, well, women have a right to abortion and government should just keep its hands off. Dworkin said, well, it was permissible for government to encourage women to deliberate conscientiously and responsibly before having an abortion, not to do so for frivolous reasons. So we show that he was perfectionist in that sense. He said government could encourage people to exercise their rights responsibly, but it could not coerce them to exercise their rights in a way the government thought was the responsible way to exercise them. But we showed that Dworkin didn't really develop an idea that government should be perfectionist in the sense of inculcating civic virtues. And so we think that's a gap in his theory. That's what we wrote about in our book, Order and Liberty, Rights, Responsibilities, and Virtues. We tried to articulate what we call a civic liberalism that would allow greater room for government to inculcate civic virtues than some liberals, including Dworkin, would. Okay. So now I could go on and on, but that's the first sense of perfectionism that we talked about in that paper. And that's an example of the way in which we show that he's different from many liberals in ways that might not be fully appreciated. He's different in ways that we think are sound, are right, are persuasive. But then we also try to push it further and show and develop ideas that he didn't develop, although we hope ultimately those ideas would be compatible with the way he would think about those issues.
Why do we have to talk and analyze not only to taking rights, but also taking responsibilities and virtues seriously?
Okay. Well, that's the subject of our book, Order, Liberty, Rights, Responsibilities, and Virtues. And I was actually just getting into one aspect of that. So let me tell you a little bit about what that book aims to do. In the United States, some people say we take rights too seriously. We take individual rights too seriously, to the neglect of responsibilities and virtues. And sometimes people who make that argument are critical of Dworkin, because Dworkin wrote a famous book, Taking Rights Seriously. And, people would talk about rights anyway, but he more than anyone is associated with this idea that we got to take rights seriously. And government is not permitted to restrict rights just because they think the common good would be served by restricting rights. Now, we observe that both conservatives and progressives have come to the belief that a lot of liberals are too individualistic and take individual rights too seriously, to the neglect of the importance of government to encourage people to exercise their rights responsibly, and to the neglect of recognizing that in order to have a system where we can honor rights, we need to inculcate some civic virtue so that people will be good, responsible citizens rather than people who just want their liberties and don't care about the common good, don't care about other people, don't care about the constitutional values, the public values and the like. So we developed, we playing on the slogan, taking rights seriously, said, well, we should take responsibilities and virtues as well as rights seriously. And we tried to show the ways in which liberals should countenance more latitude for government to encourage responsible exercise of rights in the way Dworkin had shown than some liberals do. And also, we tried to show the importance of government inculcating civic virtue. And also, we tried to show the importance of justifying rights, not just in terms of, well, I'm an individual and I have my freedom and I should get to do whatever I want to do because I've got my rights. We tried to say, no, rights should be justified, at least in part, on the basis of the moral goods furthered by protecting rights. Okay, so let me take the example of same-sex marriage. Some people would say, well, gays and lesbians should have a right to same-sex marriage because they should have a right to choose to marry whomever they please. You see the rhetoric of choice. Or think about reproductive freedom, at least in the United States. They talk about a right to choose. So it's framed as, I'm an individual, I should get to choose to do whatever I please. And we've been persuaded by the civic Republican political philosopher Michael Sandel that liberals should justify rights not only in terms of the individual autonomy that protecting rights promotes, but also in terms of the substantive moral goods promoted by protecting rights. So to come back to the example of same-sex marriage, one form of liberal argument would say, well, individuals should just get to marry whomever they damn well please. And you can understand that rhetoric. But we say, well, no, wait. The better way to justify same-sex marriage is to show that gays and lesbians are seeking the same moral goods as opposite-sex couples are when they seek to marry. They're seeking commitment and a public expression of their commitment. They're seeking to undertake not only the rights but also the responsibilities of marriage. They're seeking moral goods like security, nurture, sustenance, love, and the like. And so you justify rights in terms of the moral goods and the virtues promoted by protecting those rights. So that's another component of the rights, responsibilities, and virtues in the subtitle of the book. So it's partly about government should have a greater, we should articulate, refine, and justify a role for government inculcating civic virtue. At the same time that we recognize that institutions of civil society are important in inculcating civic virtue. But it's also a project of thinking how liberals might better justify the rights that they cherish. Okay.
Respecting freedom and cultivating virtues.
Oh, that's what I've just now been talking about.
Yes.
Okay. That's the part of the paper and a part of our book that I've been talking about just now. Michael Sandel has a famous criticism that liberal theories of justice think justice is a matter of respecting individual freedom, not a matter of cultivating virtues. And we we have an interpretation of John Rawls's political liberalism, under which it actually is more concerned with civic virtue and with public values than some people recognize. And building upon Sandel's work, building upon Rawls's work on the civic education and civic virtue side, and then reflecting upon and building upon Sandel's work in terms of how we justify certain basic liberties, we tried to develop what we called a civic liberalism that would not just respect freedom, although that is important, but would also justify the freedoms that liberals think are important, also in part in terms of honoring the moral goods and virtues that liberals cherish. And I gave the example of same-sex marriage. And in fact, our justification of same-sex marriage is very similar to Sandel's. I think we have more of a concern for equality built into our justification for same-sex marriage than he does. But we try to argue that you don't have to renounce your liberalism in order to talk this way. Michael Sandel sometimes writes as if liberalism just doesn't have the resources to talk about cultivating virtues. We have a broader view of liberalism. At the same time, we're not hostile to him at all. We accept his ideas and we're trying to build upon them in developing our liberalism. There's certain refinements we would make to Michael Sandel's ideas, but we think that within the kind of liberalism we're developing, you can both respect freedom, but also talk in terms of cultivating virtues, whether it be through civic education, whether it be through recognizing the importance of the institutions of civil society in inculcating civic virtues, or whether it be especially justifying constitutional rights on the basis of the moral goods and virtues that doing so protects and furthers.
Is it correct to think that Dworkin's theory developed a liberal moralizing kind of government?
Well, this is what I was talking about before, at the beginning. When I say moralizing, well, really, I guess you could mean several things. One, when Dworkin talked about his understanding of the American Constitution, he had various formulations for what his theory was, but I think one that elegantly captures it is the idea of a moral reading of the Constitution. So he says when we interpret the Constitution, we shouldn't just view it as some sort of antique list of rights that the framers and ratifiers over 200 years ago, or whenever a given provision was ratified, codified in the Constitution. And he said we shouldn't think about constitutional meaning as exhausted by the history surrounding the original meaning of the Constitution as it would be understood by the framers and ratifiers. He said to view the Constitution that way would be to misunderstand its character. He said the Constitution is rather like a charter of principles, like a charter of abstract moral principles. And so to be faithful to that kind of Constitution, you have to elaborate the best understanding of those moral principles. So he, in that sense, the moral reading of the Constitution, if you will, moralizes constitutional law and constitutional interpretation as compared with, say, an originalist who would want to say, well, no, you should not make judgments of moral and political principle in interpreting the Constitution. You should just make judgments rooted in history about the original meaning of the Constitution. Now, another sense of Dworkin engaging in liberal moralizing that we talk about is what I talked about before, his recognizing a role for government to encourage people to exercise their rights responsibly. In our book, we use the term governmental moralizing in a general way. And I think that if government is encouraging people conscientiously deliberate about how best to respect the sanctity of life, for example, in reproductive freedom, then we said Dworkin is countenancing some role for governmental moralizing concerning the exercise of the rights. So those, I think, are two big ways in which Dworkin's ideas, as you put it, moralized constitutional law.
Well, we are almost on time. Okay. I'm going to ask you some last questions.
Yes.
We shall identify three gaps left by Dworkin's work and stage. Yes. How we have sought to fill those gaps in the spirit of the development of constitutional perfectionism?
Well, I've talked mainly about what I call the first gap. Now, the second, we also talked about a second and a third gap, and I'll just briefly mention those. We said, well, Dworkin is an interpretive perfectionist. That is, he said we should interpret the American Constitution so as to make it the best it can be. I talked about that before. But we noted that Dworkin, that way of putting things, which we share, led some critics to say, well, Dworkin thinks that the American Constitution is perfect from the standpoint of liberal political theory. They said, Dworkin thinks the Constitution embodies every right that a liberal thinks an ideal liberal constitution would embody. So we call that the perfect constitution challenge. Now, that's an overstated objection. We think that there are elements of Dworkin's theory of interpretation that show that that criticism is wrong. For example, Dworkin would say, no, you got to make the Constitution the best it can be. So we're constrained by the Constitution we have and its history. We take the precedents interpreting the American Constitution as relatively fixed points that we need to fit and justify. And so that obligation of fitting the legal materials of the American constitutional order puts a serious constraint on the constitutional interpretation. And so when you interpret the Constitution to make it the best it can be, that constraint of fit differentiates Dworkin's constitutional interpretations, or my theory's constitutional interpretations, from those of a perfect liberal constitution, because a perfect liberal constitution wouldn't be bound by that requirement that the theory fit as well as justify the legal materials. Now, people who make this perfect constitution challenge, and they make it to me just as they made it to Dworkin, don't ever seem to be satisfied with that response. Now, Dworkin at one point was confronted with that challenge, and he said, well, yes, I do believe the Constitution should aim, in interpreting the Constitution, we should aim for happy endings. We should aim to make it the best it can be. But he said, I don't think the Constitution is perfect from the standpoint of liberal political theory. And he gave the example of welfare rights. He said the American Constitution does not protect welfare rights. He said a liberal theory of justice would protect welfare rights. So he said, see, my theory of the American Constitution does not entail that it's a perfect liberal constitution. We suggest in our paper, building upon the work of Larry Sager, who is a leading American constitutional theorist who was very much influenced by Dworkin. Sager has an approach that helps account for the thinness of constitutional law, what he called the moral shortfall of American constitutional law, how it falls short of what a perfect liberal constitution could be. And Sager says you should distinguish the judicially enforceable constitution. You should think about several concentric circles, larger and larger. The smallest one is the judicially enforceable Constitution. That's the Constitution of rights and powers that courts will enforce through constitutional interpretation. He said the next larger concentric circle is constitutional justice. And he said we should see that constitutional justice is broader than the judicially enforceable constitutional law. He said there are some constitutional obligations that are binding on legislatures and executives, even if courts will not enforce rights to government fulfilling those obligations. So there might be a constitutional right to an equal education, but courts, for reasons of the institutional limits of courts, might be reluctant to order the legislature to provide an equal education to everybody. But, Sager would say, nonetheless, there is a constitutional right to an equal education outside the courts, binding upon legislatures and executives. So that's part of constitutional justice that's broader than the judicially enforceable Constitution. And broader still is justice. And broader still is all of morality. Okay? So the point is that when you recognize the distinctions among these circles, you see how thin a moral reading of the American Constitution is. And we wish Dworkin had helped himself to Sager's formulations, because we think that is an important dimension of a moral reading of the Constitution. That it's thinner than that the judicially enforceable Constitution is thinner than constitutional justice, which is in turn thinner than justice generally, which is thinner than morality generally. And I think sometimes Dworkin's critics, who were unsympathetic, would read Dworkin as if the moral reading meant the Constitution embodied all of morality, that biggest circle, which is false as an interpretation of Dworkin. So that's the second gap that we identify in his perfectionism that we try to help fill. And then the third, it relates to what I said at the beginning about a constitution perfecting theory versus a process perfecting theory. We think the substance of our vision of the Constitution has strong affinities to Dworkin's. And we think that the Constitution protects both substantive liberties and procedural liberties. But when he talked about his constitutional theory, he, as we put it, took a page out of John Hart Ely's book. John Hart Ely was a famous constitutional theorist who said we should interpret the Constitution to perfect procedural rights but not substantive liberties. And so Dworkin said, well, there are substantive rights that themselves are preconditions of democratic legitimacy. So he said the majority has no moral title to rule unless those substantive rights are protected. And he said these are democratic conditions for majority rule. And so we said, well, we think there's a better theoretical architecture, if you will, to house these substantive liberties than to say, well, substantive liberties are democratic conditions too. Because we think that it makes it look like he's packing all of the substantive rights into the democratic conditions as if they are procedural rights. Now, to be fair to Dworkin, he didn't exactly say they were only procedural rights, but we argue that my book, Securing Constitutional Democracy, in arguing for a substantive constitution perfecting theory, that doesn't feel the need to say, oh, well, these substantive rights are also democratic conditions. We just say, no, they're substantive preconditions for the trustworthiness of the outcomes of the political process, and they're a part of securing constitutional democracy. And we say constitutional democracy includes not only procedural rights, but also substantive rights like individual autonomy, the kind of substantive rights that Dworkin emphasized. So this is, if you will, an architectural point. We agree with him for the most part about what the substantive liberties that the Constitution protects are. We just don't think you should say, well, these are all democratic conditions. We think that you should say these are substantive rights that are necessary as part of our form of constitutional self-government. Okay?
Okay, Professor Fleming, well, I am afraid we're on time, and that's the end of the interview. And for the last, we will hear you some very last reflections about the work of Dworkin today, and some words of coming from you to end this interview. Please.
Thank you. Well, again, it's been an honor and a pleasure to come down here to UNAM. To engage in serious reflection upon Dworkin's contributions to legal philosophy and constitutional theory. And it's been inspiring to me to see how many people came. People came from Colombia, from Brazil, from Argentina, and it's just heartening to me that it's heartening to me that there's such a strong community of scholars who want to come together and reflect upon Ronald Dworkin's contributions. And I'm especially impressed with Imer Flores' seriousness with which he has studied Dworkin's ideas and tried to grapple with Dworkin's arguments. It's encouraging to me to see that he, his colleagues, and his students are taking these ideas so seriously. And I repeat, it falls to us to carry forward that work and to build upon Ronald Dworkin's monumental achievement. He was a great inspiration, an extraordinarily powerful figure. We'll miss him, but we will honor him best by carrying forward his work. Thank you very much.
Thank you very much to you, Professor Fleming, and we really appreciate the time you gave us to this interview, and we would like to see you again in Mexico in a few time.
It is a pleasure to come back. I do hope to come back again, and next time I hope that my co-author and wife, Linda McLean, will be able to come with me. Thank you.
Thank you so much, Professor Fleming.